welcome to today's webinar, Protecting Your Client Against Ground Rent and Estate Rent Charge Problems. Most of you will be familiar with myself and Ian by now, even if only in a virtual capacity. My name is Stephen Smith. I'm the country manager at Stewart Title Limited. Ian is a qualified solicitor and has also worked in private practice and as a consultant. And through his business, IQ Legal Training has delivered 1,500 training courses for city and regional firms, local law societies and local authorities. We also have my colleague Robert Kelly online today, who's our Commercial Business Development Manager and also a qualified solicitor. Good morning to both of you.
Morning, Stephen. Good to hear from you again. Morning, Robert. Morning, everyone.
For those of you that have been avid viewers of our webinars, I apologise in advance for once again going through the control panel. I know it gets a bit tiresome, perhaps, just a bit like the safety briefing at the start of the flight, I guess, but that's more useful than this. But at the same time, it's good to get people set up and involved so they can be interactive with the webinar. So you're listening through your computer's speaker system by default. If you prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. This can be toll-free, and I've always said it's toll-free for UK. I believe you can also get toll-free if you are dialing from outside the UK as well by selecting the relevant country. You'll have the opportunity during today's presentation to submit any text questions to Ian by typing the questions into your questions pane of the control panel. You may send in your questions at any point, but we will collect these at the end, and as you will be aware, we do a Q&A session once Ian has finished his part of the presentation. You can also raise your hand. There's a button there to raise your hand on the control panel during the presentation. If you're having any IT issues or sound issues, please also use the raise hand or text to get in touch with me, and I'll try and resolve any issues if possible. And also, if you would like to ask a question over the speakers rather than by text, you can also raise your hand. Let me know and I'll unmute you to speak to Ian directly. Just finally, you'll hopefully see that we've added the notes to the handout section today. To access it, simply just click on the document itself. The handout file will automatically start downloading on your browser. There are some browsers as well where it will actually just automatically open for you. Again, if you would like to access that and you're having any issues, please do, and I should be able to help with that. We'll also be running a couple of polls throughout the presentation about halfway through today to keep you engaged, and we look forward to your participation in those. But without further ado, I will now pass you on to Ian for the main part of the presentation. So over to you, Ian.
Thank you, Stephen. Stephen, I'm amazed when you mention avid viewers. It's a term I'm not used to with all the number of webinars, face-to-face tuition I've done over the years. So yeah, amazing. Yeah, good morning, everyone, and thanks for joining us again. What we're going to be doing today is looking at ground rent and some issues with regard to rent charges and indeed estate rent charges. There's some important points that I want to sort of highlight relating to both issues, and there are some issues relating to best practice. So, ground rent and rent charges, not the same thing, of course, obviously, no real sort of common factors between the two, but other than creating problems for residential conveyancers. So the first thing I want to talk about today is some basics relating to ground rent. And of course, our starting point, well, what does the lease say with regard to ground rent? I'm often asked this question: if the lease says the ground rent is 5 shillings, well, what's the position? Well, the position is that the ground rent is the modern day equivalent of 5 shillings. I, over the years, have done lots and lots of work on behalf of landlords and reversioners, either house builders who've sort of retained reversions or investors who acquired reversions. At one stage, there was a very, very buoyant market. And one of the common sort of ploys that I saw from landlords and reversioners, and even some decent ones, was where the lease would reference, I don't know, to the ground rent being 5 shillings, is that the landlord would say, well, there's no such thing as 5 shillings, so I can charge what I want. And I had one landlord in particular where the lease was 1 shilling per annum, And he said, well, no, let's ignore that. And the actual ground rent is £100 a year. And I imagined there to be howls of protest from leaseholders and their advisors. And I was amazed as to how infrequent there was any howling at all. Most just seemed to pay it. So the important point is check what the lease says. If the lease is an old lease and the ground rent is, 6p a year or something, then that's it. Significantly, on lease extensions, again, if I was advising or dealing with a landlord on a lease extension, as part of the negotiation process, the position might be, well, we'll grant you a new lease, we'll grant it on the terms that you're suggesting, but we want a more realistic and modern ground rent payable. Remember that if the matter is tested before tribunal with regard to the terms of the new tenancy, then the rent would be a peppercorn. So what does the lease say? Second point, is there provision within the lease for ground rent review? Just because there is a ground rent review, alarm bells should not automatically ring. The issue is, can I determine what the ground rent will be at review? And is that review, is the mechanism for review likely to lead to a reasonable sum with regard to ground rent? Now here, there's quite a bit of information I'm going to share with you, and some of that information, in my view, to an extent, runs contrary to some of the advice that you may have seen. I'll explain why as we approach that. And then the last point I think is really fundamental, and again, I'm astounded as to how infrequently this point is taken up and landlords challenged. Ground rent has to be in statutory form. The Landlord and Tenant Notice of Rent England Regulations 2004, there's an equivalent set of regulations for Wales, specify that a demand for ground rent has to be in statutory form. So if a landlord just simply sends out an invoice, a computer-generated invoice to leaseholders, that is not a ground rent demand that complies with the legislation and regulations. It must be in statutory form. If you want to see what that statutory form is, if you go on the Leasehold Advisory Service website, you will see a precedent. Now you're going to say to me, well, hang on, Ian, does it really matter? Is it really an issue? And in the notes, I mention a case of Cheer Up Mate 2 Limited against the Luca Calca, which is a 2017 case, which went before tribunal. And one of the issues that the tribunal had to determine was whether the ground rent was properly due and owing. And the issue was, let's examine and explore the ground rent demand. The ground rent demand must be in the prescribed form for it to be due and owing. It must set out the specifics, the amount of payment, the date on which the tenant is liable to make it, if different, the date on which he would have been liable to make it in accordance with the lease, and further information as may be prescribed by the regulations. There's also a date on which the tenant is liable to make the payment, which again must be specified. So don't forget to deal with basic points. It's like what we said in the past in connection with service charge. Service charge is not due and owing unless the leaseholder receives a demand for service charge along with a statutory notice as to their statutory entitlement to challenge that service charge, which again is in a set format. If it's not in the correct format, then the service charge is not payable. If the ground rent demand is not in the correct format, the ground rent is not payable either. The next point to note is, with regard to ground rent, it's not a new problem. The idea of ground rents doubling every 5 years or 10 years and the extraordinary amount of rent that is due and owing as a long lease progresses isn't new. It was highlighted long ago with regard to problems and issues. It didn't lead and hasn't led to many claims historically against conveyancers. More recently, in 2016, we began to see an appetite for reform relating to ground rent reviews and onerous ground rent provision. And of course, the government has sort of latched onto this in recent years, and as have the sort of press, and therefore it is a sort of hot potato at the moment and has been for a while. One of the reasons why the Common Hold and Leasehold Reform Act 2002 introduced common hold, and one of the reasons why some contend that common hold will be reintroduced, is the idea that ground rent, in essence, is just a means of generating pure profit for landlords and retainers. On the issue of common hold, just so that you know, I had an email from the Law Commission this morning because I was sort of pressing them as to when we're going to hear about their report, still sort of in lockdown, and no date really as to when the report's going to be available about reform and reintroduction of common hold. So, what's the original ground rent? Next, we've got to ask ourselves, what's the frequency of review if there is a review? There isn't anything that would say a ground rent review provision is onerous due to an extensive or frequent review. So a review every 2 years, 5 years, etc., isn't per se generating some form of onerous provision. It is the mechanism for review that's the key. And the big thing that everyone is sort of drawn to is this idea of ground rents doubling every 5 years or 10 years, etc. So if there is a ground rent review provision in our residential lease, of course, we've got to advise our client when that review takes place. We've then got to review the mechanism relating to the review process. And here, some significant points I want to sort of dwell on. Point number one, if there is a complex formula or some form of complex calculation with regard to review, then proceed with caution. Can I determine what the ground rent will actually be at review? Is the mechanism, is the formula, is the calculation such that I can work out what it will be? If that is the case, then again, there's an argument that the provision isn't onerous. The calculation and formula may be very unfair and may be very beneficial from a landlord's perspective, but we know what it's going to be. Our client is proceeding with their eyes wide open, and therefore we can't argue, we can't contend, and our client should not contend that they've been sort of hijacked or surprised with regard to the rent in the future. Of course, all of this hinges upon the fact that we're explaining to our client precisely what the ground rent is and when the review takes place and the mechanism or formula for review. And on that point, we go back to what we said in the past. Remember, those of you that attended the previous webinar when we discussed leasehold issues, making sure that we're explaining to our client in terms that the client understands what the lease actually says. And again, I'm going to go back, but I don't mind repeating what I've said in the past. It isn't enough just simply to give the client a copy of the lease and say, read that. It is important that we set out the fact that the lease contains provision for ground rent, contains provision for review, and this is what will happen when that review takes place. Remember, I mentioned to you the Leasehold Advisory Service guidance about leasehold ownership and the Association of Residential Managing Agents guidance as well. These two documents highlight this point. And remember what we said about the SRA and the Law Society, highlighting that we need to draw the distinction between freehold and leasehold ownership and the disadvantage of leasehold ownership, ground rent being one of those disadvantages. So I'm asking you to determine whether or not future ground rents are ascertainable or not. If they are ascertainable, then fine, we tell the client what the position is. Where ground rent is doubling every 5 years or 10 years on a long residential lease, at some stage during the term of that lease, the provision is going to become onerous. And we've got to advise our client that they should not be proceeding with such a provision. I'll show you a little later the ammunition that you can use with regard to a new lease or with regard to an existing lease and a landlord that's being unwilling to sort of negotiate or unwilling to assist with regard to varying the lease. A point that I'm concerned about, but others don't seem that concerned about, is where we've got future ground rents that are linked to some form of indices. For example, ground rent that's linked to the inflation rate at the time of review, ground rent calculated by reference to the retail price index. In those circumstances, the problem that I've got is what is the retail price index when the review takes place? What happens if there isn't a retail price index? As far as inflation is concerned, we're very lucky, aren't we? Surprising to say that, really, but we're lucky that at the moment we've got inflation that's next to zero. But some of you, like me, can remember perhaps times in the past where inflation rocketed. So if we were unfortunate and inflation were to rocket again, and there is an argument that we're not unfortunate where inflation rockets on the basis that wages tend to rise, but if we're unlucky from a ground rent perspective to have a review at that point, we could see the ground rent increasing by 10, 15, 20, 25%, whatever inflation is. And the same point goes for retail price indexes and any other form of indices that could be used. Another thing that worries me is where ground rent is a percentage of market value, because again, you might be able to say, well, yeah, all things being equal, property prices rise at a particular rate. And therefore, hey, we are able to have a guess at ascertaining what will happen at review. But I dealt with a matter a few years ago where this person bought a property in a particular hotspot in a street where the prices of the properties in that particular street rocketed, whereas the prices of property in the town and in the vicinity didn't. Well, again, in those circumstances, if the ground rent is reviewed on the basis of the property value in that particular street, the client who was going to be paying the ground rent would get a terrible shock, and indeed did get a terrible shock. So with regard to advising clients, there are some sort of basic points to note. If you look at page 4 of the notes or so, you'll see some detail that I think is significant, and this is probably of more benefit to you. I'm not necessarily saying that you disseminate this information to clients, but it's important that you're aware of the position, and depending on the client, again, if a client is risk averse, there are some issues that we can highlight and draw to the client's attention that perhaps would make them see the wisdom of either seeking an amendment or variation to the lease, or indeed not proceeding with the transaction at all. And the first, of course, is the Housing Act 1988 trap. The problem here is that if we've got escalating ground rents, we could have a position where the ground rent exceeds the limits under Schedule 1, Paragraph 3A of the Housing Act 1988, meaning, in essence, that we've got a situation where we have a tenancy that is no longer protected by the protection afforded by legislation relevant to residential long leases, and in fact becomes subject to the protection afforded by the creation of assured short hold tenancies. In those circumstances, does it really matter? Well, the answer is it definitely matters. Why? Well, one, the availability of relief from forfeiture disappears. Secondly, other issues, rights of first refusal, etc., are no longer available. And the mechanism for gaining possession becomes significantly easier. So watch out for that. Next point, this issue about indexation that I've mentioned already. Again, that can create significant difficulties. As far as indexation is concerned, the problem that I've got there is the situation where I'm unable to determine what that indices will be at the time of review. If there are rent review provisions in a lease, are they acceptable to client and lender? Well, again, our client may be relatively inexperienced with regard to leasehold transactions, and therefore may not be fully aware of the potential problems or pitfalls where we're looking at ground rent review that potentially could create difficulty in the future. As I mentioned in the past to you, the average period that a leaseholder will own a flat is 5 years. So if there's a ground rent review at 10, is it really going to matter from the client's perspective? Well, the answer is it may not matter to the particular client, but it's certainly going to matter with regard to sales. And certainly I notice, and practitioners I'm sure will notice, the fact that in the past, this issue of a ground rent review or owner's ground rent provision within a lease might not have been a concern in connection with the purchase of a leasehold property. These days it is. Practitioners are alert to the problem and aware of the problem, as are clients. Even if clients aren't aware, it's imperative that we draw the potential problem to their attention. From a lender's perspective, there's an additional issue. And as far as that is concerned, it is important that we understand a particular problem that lenders have relating to ground rent review. And that's an issue relating to the fact that in determining their lending, the position relating to ground rent can create a problem for them on the basis that they will use a formula to determine the amount that they're prepared to lend in connection with a leasehold property. And therefore, if there is a ground rent review provision within the lease, this can generate quite severe difficulties from a lending perspective. Remember what we said about vague or ambiguous provisions. If a lease contains vague or ambiguous provisions, and here I'm focusing in on ground rent, remember we are under a duty to explain that this is our interpretation of this ground rent clause, but it is vague or ambiguous, and our interpretation may be wrong. And the only real way to test whether the clause is enforceable or not would be to take the matter to tribunal. Remember the point that I've made in the past, providing a copy of the lease is not enough. It is necessary for you to give advice relating to the lease. And at page 6, I highlight and repeat the conveyancing protocol. We've got to specify the residual lease term, the amount of ground rent payable, the method and timing of increases in ground rent. So the protocol specifically emphasizes that a buyer should be made aware of those facts. If a lease is defective, and this is significant, then there are a number of potential ways to resolve those defects. Firstly, if we can establish that the lease was created mistakenly and the ground rent provision or ground rent review was made erroneously, then it may be possible to apply to the court for rectification. But remember, it would be necessary to establish and to have evidence that both parties made a mistake. The fact that our client has entered into a bad deal or the original leaseholder entered into a bad deal is not going to generate an opportunity to allow an application for mistake. It is possible to think about variation by agreement. And this becomes an interesting point. Some landlords, some reversioners are very switched on, very reasonable, very aware of publicity and adverse publicity, and will be willing to vary the lease to ensure that the ground rent then becomes a more fixed and stable sum. So you might have a situation where a landlord says, well, okay, we'll forget about ground rent doubling every 5 or 10 years. We'll have an increase of, say, 5% on a 10-year basis or something of that nature. So there are some landlords that will be very receptive to an approach to vary. There will be others that will be very reluctant to do so on the basis of A, this is a brilliant means of generating significant income in the future, or more likely, this is a great lease, this is a great reversionary interest that I can sell on at a vast profit as and when reviews are approaching. So you might get some resistance. As far as applying to vary the lease is concerned, remember the Landlord and Tenant Act 1987 has some jurisdiction to vary defective leases, but that jurisdiction would not extend to, in essence, a bad bargain. Lots of cases relating to the courts highlighting and tribunals highlighting that a defective lease is not necessarily a bad lease from a leaseholder's perspective, because the leaseholder has entered into a bad bargain would not entitle the leaseholder to apply under the 87 Act for variation of the lease. So be careful if our client embarks on accepting a lease with onerous ground rent provision. The important point to be aware of is that we're not going to be in a relatively easy situation in seeking an amendment to the lease. The only point I would make there is sometimes a landlord or a reversioner might be wanting to sort of tidy up some other issues relating to the lease and might therefore be receptive to a suggestion that the ground rent provision is tidied up at the same time. And in doing that and in approaching that, you could mention something that we're going to examine in a moment or two, the 14-point leasehold pledge that builders and developers have entered into in recent years. I talk in this next slide about onerous and unusual ground rent provisions. I was reading a report, a parliamentary report, where a number of the major house builders were called before a select committee to sort of explain themselves with regard to leasehold houses and ground rent provisions relating to leasehold houses. And I remember Chief Executive Persimmon Homes was basically saying, well, you talk about onerous clauses within a lease, but there isn't really a definition of an onerous clause within the lease. And I thought, well, yeah, he's got a point there. So I just went scurrying off and determined by looking at cases and looking at tribunal decisions that when we talk about onerous clauses, we're talking about an unreasonable and or unacceptable clause, unreasonable or unacceptable to either landlord or leaseholder. It is important to highlight any clause which appears unreasonable or unacceptable, either unacceptable objectively or unacceptable from a subjective perspective given client's objective. Talk about the Housing Act trap. I haven't mentioned something I want to mention to you: shared ownership leases, Richardson and Midland Hart. I hope you've all seen this case. I refer to it in page 7 of the notes. What happened in this case is this lady acquired a shared ownership lease, paid 50% of the purchase price for the property, so acquired a 50% beneficial interest in the leasehold interest, but then was paying rent to the housing association. And then, and I didn't quite get to the bottom of the position, whether she was aware she wasn't paying it or just simply forgot. But because of personal circumstances, she moved out, she got behind with regard to the rent, and the landlord issued possession proceedings relying on the mandatory ground 8 for possession. Went before a district judge, and the district judge awarded possession. Her argument was, well, hang on a minute, I've bought 50% of this leasehold interest. Surely you can't take my property away from me, given that I already own half the leasehold that is now subject to these possession proceedings. The district judge wouldn't have any of it. In essence, you are due to pay rent. It doesn't matter how small the rent is compared to what you've paid for the property, no matter what the beneficial interest is. You've entered into a tenancy agreement of sorts. You've got to comply with it. Interesting case. If you are dealing with shared ownership leases, be aware of it and make sure you drum into the clients, no matter what their contribution is, no matter how much they've staircased, etc. If there is an element of the beneficial interest still held in the hands of the landlord, then the rent has to be paid, and if it isn't, then woe betide the leaseholder. I mentioned in the notes the 14-point pledge generated by builders and developers. Not all of them have signed up to it, but in essence what they're saying is if we've got ground rents that double every 20 years or less, then we're happy to review the lease, and we're happy to agree a variation to the lease, and to then link the ground rent review to retail price index. I've already mentioned that a word of caution should be given to clients about using the retail price index, and that warning, I think, stands true with regard to this point. As far as processes are concerned, they should be uncomplicated, transparent, and fair. Landlords should be supporting collective enfranchisement and should have complaints processes and redress schemes that are available to leaseholders. There are specific provisions with regard to new leases, and there are also provisions that are pertinent to new and existing leases. And we can't really leave the issue of ground rents without exploring suggestions for reform. The government has published plans for tackling exploitive practice in the leasehold sector, mainly due to the work of organisations such as the Leasehold Knowledge Partnership that I've touched on in the past. There's been a great deal of discussion about ground rent. Some landlords and owners of reversions have maintained that ground rent is essential to make leasehold schemes work. And the argument they put forward is not all of our leaseholders pay service charge. They either don't or they can't, and therefore there are often situations where there are gaps relating to service charge. And what we can do is utilise the cash that comes in with regard to ground rent to meet shortfalls. Well, I'm not entirely sure that that's right. Because the ground rents probably are not going to be sufficient to meet situations where there are lots of shortfalls. And secondly, impossible to connect ground rent to maintenance obligations. and therefore it's going to be difficult, if not impossible, to ensure that if we've got a number of leaseholders not paying service charge, that the ground rent's going to come anywhere near the position of sort of recovering cost. Also, as far as ground rent is concerned, there is an appetite to reform the leasehold system so that we're taking leasehold houses out of the market. And again, the Law Commission has looked at this in addition to its sort of review of common hold. And finally, there has been some attempt at looking at reform with regard to equal rights to freeholders, which leads me nicely into what we're going to be talking about next, relating to rent charges. Before I do that, however, there are two things I'd like to do. First of all, Robert, can you tell me what sort of product is available with regard to any problems that conveyancers have relating to ground rent issues? So is there a specific product relating to ground rent, and could you explain it to delegates today if possible?
Yes, certainly, Ian. As you say, this problem of ground rents normally arises when somebody tries to sell a lease, not at the initial stage.
Yeah.
And then lawyers have found themselves in a difficult position of a onerous ground rent with review provisions that is potentially dangerous, as you've said. And the remedies, as you've outlined, are fine if you have a reasonable landlord who's willing to play ball. Otherwise, you're looking at very long, considerable delay in a transaction. And whilst we don't, as a matter of course, protect people against bad deals, unfortunately, that's a thing really for them to negotiate it or to have their lawyer advise them on. What we have prepared is a Housing Act forfeiture of lease possession policy, which covers exactly the situation. It's a lender-only policy, so it gives cover to lenders who will be, of course, driving this, because your duty in the purchase is no doubt almost certainly to advise the lender as well as the buyer, and the lender is at risk here because of the loss of the right of relief against forfeiture. So we have a policy here. It covers lenders against any costs incurred or losses suffered, and it's meant to be really a quick way to help you get the transaction going forward. It doesn't remove your duties to advise your client about the possible ramifications, but in the if you're looking at a property for 5 years, 10 years, as you say, this is a policy which will enable you to get that transaction going. And on it, premiums start at £15 for £100,000 worth of cover, and go up, as all of our residential ones, up to 3 million. So it is there. It's a mechanism really to enable you to get the transaction to go forward, give the lender some comfort, and allow a transaction to complete.
Yeah. So Robert, if I'm a lender, I can see a situation where either my lawyer is telling me you can't lend on it, it's not good security, or my process is I'm not prepared to lend on it, end of story. So your policy then fits in quite neatly and affords the protection for the lender, doesn't it? So that's quite neat and enables the deal to proceed. As you quite rightly say, it doesn't sort of alleviate the problem from the buyer's perspective, but invariably, as we've discussed in the past, if the lender says he's happy, then the client's happy as well. The problem with that, of course, for everybody is that you've got to be ultra cautious about ensuring that you've protected yourself with regard to the advice to the buyer client. So the policy protects the lender and cuts off that issue, but again, means we've got to be really careful about protecting ourselves and indeed protecting our client with regard to the warning that there is this vulnerability relating to the lease. Thanks for that, Robert. Stephen, I think we've got some polls, haven't we? We've got a couple of polls.
Yeah, I thought a nice opportunity to sort of interject with the poll. While I'm doing that, Ian, actually, I'm going to break away from the trend as well, because I think the subject of retail price index and inflation was a bit of a hotbed of discussion in the background. So there's a lot of questions. I'll just ask a couple, if that's all right, Ian, while I'm running this poll. So let's start with the poll anyway. The question we're asking is, have you or your firm experienced problems with lenders regarding ground rents in leasehold properties. So I'll just launch that and give everyone a second to do that. So Ian, just while that poll is open, just a couple of questions then, if I may. So Robert McAley has asked, I act for a client who has a ground rent review every 15 years. The landlord has offered to switch the review from a 15-year regular (brackets doubling of) ground rent review to a 15-year RPI. The landlord wants 6 months. What would Ian recommend?
My recommendation is you say to the client, I don't know what the RPI will be at that juncture, so it's impossible for me to determine what the rent will be reviewed to. But as far as a negligence claim is concerned, Law Society guidance seems to be that you're perfectly entitled to advise the client to proceed on the basis of RPI. It's a personal thing. I don't, and as I say, I got caught out with regard to inflation years ago, and therefore, it's all well and good to say, yeah, we'll connect to an indices, but what happens if anything happens relating to that indices? So I would, in a situation such as that, I would proceed, but I would warn the client, Mr. Client, I can't tell you what RPI will be at that point. I can't even tell you if RPI still exists. What I might do, if I was given a position and I had equality of bargaining position with the landlord, I might say it's linked to RPI, but it can't exceed an increase of, say, 5% or 10%. Put some form of cap or ceiling on it, Stephen, would be my view.
Yeah, okay, no, that's very useful. Thank you, Ian. I think we have another one. It's kind of not necessarily similar, but I think you've kind of touched on that there. Can we tell whether rent will become onerous just because of it doubling? We cannot tell what future money value stroke inflation will be. Ground rents from earlier centuries. Yeah.
That's true. So, I mean, there's an argument that until the review happens, we've got no idea because, like I mentioned, let's say inflation goes crazy, then a ground rent that doubles every 10 years and that is, £540,000 in, say, 500 years' time might be nothing. But at the same time, we are advising clients as of today, and that amount of money would be a horrendous amount of money, and that provision is going to make your property potentially unsaleable. So I take the point that we don't know. It might be that £500,000 is the equivalent of £50 per annum now in 2020. Yeah, I thought when I put that in, I often get practitioners sort of getting a bit jumpy when I start talking about indices, etc., on the basis that there is advice that a review linked to RPI is acceptable, and it probably is, given what RPI currently is at the moment. But the point I'm making is we have no idea where it's going to be in 10 years, 15 years, 20 years, etc. So the same principles sort of apply with ground rent review being connected to a percentage of market value of property. Good questions, both of those, Stephen. Stephen, I'm just looking at your poll. Interesting.
Yes. Yeah, quite split. I'm a bit surprised myself by the split. I thought yes, maybe a bit higher than that, but I mean, what are your thoughts there, Ian?
Yeah, same thing. The important point is that as far as experienced problems or encountering problems relating to leasehold properties, it's I think the fact that a lot of practitioners are aware of the problem. I envisage, however, that the vast majority of clients, and it goes back to this point we've made in the past about residential transactions, I want the house, I want the flat, therefore I don't really care about what happens to the ground rent in 10 or 15 years' time. So it's quite a difficult piece of advice to give clients, quite a difficult warning to give clients on the basis, well, you're just being negative again and you're just holding this deal up and trying to prevent it. What I often see is estate agents saying to clients who are buying leasehold flats, well, yeah, there is this provision, but hey, don't worry about it because 10, 20 years time, etc., you're unlikely to be there in any event. Interesting. You've got to watch lenders. There isn't a sort of common approach from lenders, and therefore it's interesting to say only with certain lenders there are problems. A lot more are switched on to this. A lot more have firm views relating to whether or not they're willing to accept, say, ground rent that doubles every 5 years on a residential long lease as adequate security. Great poll. Is there another one, Stephen?
Another poll, yes. So the second poll, actually, it's moving on to the subject we're about to talk about, estate rent charges.
Can you look at it now?
So I'll just hide that now. So the question is, do you always advise the lender if there is an estate rent charge? So I'll just run that poll for a moment. Actually, while we are running that poll, because we have, I think I counted about 15 questions on that original subject. We might be able to come to a few at the end. I will ask just another one while that's running there. So yeah, I've had a few lease variations, instructions where the original developer has instigated changing the Dublin ground rent provision to relate to RPI instead. They were only agreed to do this with the original first buyer of the apartment. As the RPI reference appeared to be a better arrangement than doubling terms, we have not been able to advise against the RPI arrangement. But from what you're saying, this is not ideal either. Should we in fact be reluctant to take on this type of work?
No, my attitude is that it's perfectly satisfactory to proceed. The guidance, particularly from Law Society, seems to be that you're not going to be negligent if you are sort of varying a lease ground rent that doubles over 10 years to a ground rent that is varied in accordance with RPI. But all I'm saying is, in your letter to the client, you're warning the client neither you nor I know what the RPI will be in the future. And just as this groundswell of problems relating to ground rent has arisen over recent years, it might be in 5-10 years time, if something crazy happens to RPI, that we've got the same issue all over again. Although this time, it's the fact that the retail price index has gone through the roof, and therefore ground rents are going through the roof.
Yeah, no, thank you.
I thought it would get people, so it always does, to be honest. It's my Dominic Cummings moment, this one. I thought we'll just put that in there and see what people think. Because a lot of people do think, well, hang on a minute, no, but you must see the point. It's like any form of indices. How do we know what it is, or do we know that it even exists? So if I was in a situation where I'm dealing with a landlord, yes, I will say, okay, let's have a review connected to RPI, but let's have some form of ceiling so that if RPI does all of a sudden rocket, I'm not committing my client to something that's going to cause him problems in the future. Interesting answer to this one, Stephen.
Yeah, so the question, do you always advise the lender if there is a state rent charge? So 62% saying yes. That's interesting. So why do you think that no would be quite high in this instance?
Yeah, well, quite simply, a lot of people look at an estate rent charge and do not appreciate the difference between an estate rent charge and a rent charge regulated by the 77 Act. As far as the 77 Act is concerned, there are mechanisms that enable the rent charge to be subject to some form of confinement that doesn't apply to estate rent charges, Steve. But great, very interesting that. So if I go back to my slides, if I may, hopefully we can see them. Yeah. Can everyone see those slides, Stephen?
I think so. I mean, I can see them in, so yeah, they should be up.
Lovely. So can I proceed?
Please do. Thank you, Ian. Thanks for that, everyone. Thanks for taking part.
Item 2 in rent charges. What is a rent charge? An annual or other periodic sum payable annually or biannually, which is a charge on the land. It excludes rent reserved by a lease or tenancy, or any sum payable by way of interest. As far as section 2 is concerned, it is important to understand that no rent charge can be created, whether at law or in equity, after the coming into force of this section. And rent charges per se, traditional rent charges, not estate rent charges, expire in 2037. So why would we have, or why have we seen rent charges in the past? Well, we've seen them as a method of protecting payments for service on estates. Where we're selling freehold houses, we can't really impose any form of service charge per se. We have to use leases for that purpose. We can use a rent charge to recover cost relating to service or services that are provided in connection with a freehold development. So the last time I created an estate rent charge, we had a housing development of 20 units. The houses were approached by a drive that was 2 miles in length. And the situation is that there was not an appetite for potential buyers of these large houses to own leaseholds. So the only way that they'd be willing to pay what were fairly substantial sums for these properties were if they were acquiring a freehold. But the problem was that there was an issue of cost of repair and maintenance with regard to this 2 mile lane, and therefore we created an estate rent charge. More on that a little later. But that's the sort of common way that you would encounter historical rent charges and the way that you're likely to encounter estate rent charges today. Of course, with the demise of leasehold houses and with the criticisms relating to leasehold generally, we're likely to see more and more freehold houses, and therefore where there are services that are being generated, the use of an estate rent charge fits the bill. Of course, if common hold takes off, then the need for a sort of estate rent charges, or the need to avoid residential leases, disappears. A rent charge is a mechanism for a third party called a rent receiver to secure payment of money or to enforce positive obligations against an owner, described as a rent payer, over a property that's described as the burdened property. The third party, the rent receiver, has no interest in the burdened property, so that's why these provisions don't apply to rent or other payments. But it generates a problem, and the problem is that whilst I have statutory protection relating to ground rent and service charge in the context of leasehold, I don't have that protection with regard to rent charges. It is important to understand that with regard to rent charges, in order to be binding, there is a need for them to be registered at the land registry. And because of that, if a lender is funding a purchase or a remortgage of a property, then they are going to be subject to the rent charge that's protected by registration, and their charge will take subject to that rent charge. So a rent charge, just for those of you that are interested, is a legal interest in land. It should be registered at the land registry with its own title and noted against the title affected, Section 3 of the Land Registration Act 2002, and once that has taken place, it's binding on all future owners. The Rentcharges Act, which applies to rent charges but not estate rent charges, states that all existing rent charges are to be extinguished on the 22nd of June 2037. It's funny, you look at that and you think, crikey, that's a long, long time away. And some people, particularly my age, think, will I still be in practice or will I be retired and looking after the allotment? Important to understand that existing rent charges are still valid. The 77 Act precluded the creation of rent charges, so they are a sort of dying breed, as it were. But there are historic rent charges that are in existence. I think the Land Registry did some work and there are thousands evidently still out there. The important point with regard to a rent charge that doesn't apply to an estate rent charge is that it's possible to redeem the rent charge subject to a payment. So we can terminate a rent charge. We don't have that facility with regard to estate rent charges. So problems. One, we don't have the protection that leaseholders have relating to ground rent and service charge, issues of reasonableness being the obvious. The rent charge continues to bind all the land, even if it's later divided or sold off in plots. A party that has the benefit of a rent charge can require any one homeowner on the land that has been divided to pay the entire rent charge amount. We're in the realms of provisions relating to chancel repair liability, aren't we, in that sort of context? So the payer would then be entitled to collect contributions from other non-paying property owners. But the problem there is, A, do we have the appetite to do that? Are we prepared to issue proceedings? And are we satisfied that we're going to be able to get full recovery in those circumstances? The rent charge may specify that a rent owner can agree to collect various rent charge portions from each property owner. But again, there can be complications relating to apportionment. There could be an informal apportionment. And again, there could be issues with regard to what we advise and how we advise our clients. So lots and lots of potential problems relating to rent charges generally. In particular, Section 121 of the Law of Property Act 1925 enables the owner of a rent charge to take possession of the property and use the income from it to clear arrears. And the rent owner is allowed to grant a lease of the property to trustees to raise and pay the arrears and associated costs. A deep breath, and we have to think again about nasty landlords, and we have to think here in the context of nasty third parties. So we could have a situation that a rent owner is owed £15, £10 by way of rent charge, and is thinking, what can I do to sort of maximize my return with regard to this fairly inconsequential amount of money that's owed to me? I am entitled to create a lease. I could then potentially take, or more accurately, trustees relating to that lease have the right to take possession to the exclusion of the freehold owners. And the only way that the freehold owner can then extract themselves from this bind is to attempt to come to terms with me to force a surrender of the rent charge lease. And if that approach is taken, haha, says the rent owner, I've got costs that I can rack up, and I can ensure that I'm now making a significant amount of money out of my £10 per annum rent charge. That's the problem. The entitlement under Section 21 arises if a rent charge remains unpaid for more than 40 days, even if it hasn't been demanded, and no matter what the amount outstanding. So again, with ground rent and service charge, the need for demand, there's need for notification of statutory rights, no such protection for property owners with regards to rent charges. So what do we do? How do we deal with this? Well, again, we're back to communicating with our clients about what the rent charge is and what it does. Next point, important to understand that just because we've got details as to what rent charges have been levied in the past, there's no indication that that will be a fair representation of what rent charge will be in the future. So lots and lots of potential problems. So what do? We warn our clients about the way a rent charge operates. We warn our clients that there is vulnerability if the rent charge isn't paid. So we urge our clients to make sure that all rent charges are paid immediately. We are aware of them, and we explain to our clients the position with regard to what the rent owner can do in order to enforce rent charge and the very onerous provisions relating to it. I've given you in the notes 17 and 18 Orchard Trading Estates and another case of Smith Brothers Farms Limited that show the potential problems relating to rent charges generally. So the important point here is that there is no protection and no right to relief with regard to the creation of this lease and the opportunity for the rent owner to generate costs. And as I state on this particular slide, no need for a demand at all. I mentioned in the notes land registration issues, fairly straightforward really, to be honest with you. Rent charges are a legal interest and require registration. The position with regard to estate rent charges is slightly different in that an estate rent charge can be protected by way of notice, Remember what I've said in the past about the use of agreed notices rather than unilateral notices. As far as an estate rent charge is concerned, it is created and designed to protect positive covenants and make them binding on a title, not affected by the Rentcharges Act, so no right to redeem, no right for statutory apportionment. As far as the right to redeem is concerned, a useful mechanism with regard to rent charges, but not estate rent charges, allowing in essence the rent charge owner to be paid off by the payment of a fairly small amount of money. I've given you details relating to that at page 22 of the notes. I repeat that that isn't available for estate rent charges. An estate rent charge is likely to be detrimental to lenders, as I mentioned in 23 of the notes, because one, we've got this potential problem relating to default, relating to payment and the entitlement of the rent owner as a consequence. We've got a registered rent charge lease being binding on the owner of the property, as well as a lender in possession, and then any future purchase, and therefore likely to consider or amount to a considerable detrimental impact in connection with the security of the lender. Important to understand, as I've mentioned in the notes at page 23, that title insurance might be available. Now, Robert, I think you've got some news, haven't you, with regard to product development relating to this particular issue. Could you come in and assist, please?
Yes, certainly. And yet again, yes, you're quite right. This is problems been arising more and more in the past year. So we have been working on finding a really practical and simple resolution for it to protect lenders again, because as you say, the actual homeowners, if properly advised, know when to pay and should pay. But for a lender, the 40 days is a very short time. They may not be aware that the client is under any financial difficulties. So they feel very exposed here. So we do have a new policy, very similar to the cover given by the ground rent policy, which is just in the final stages of approval now, so should be available shortly. And again, will protect the lender against loss in value and costs incurred should this happen. And again, is intended to allow a transaction to move forward because more and more lenders are concerned about this. One caveat, just to be entirely frank about it, is that I do think that still some lenders won't accept title insurance in this case. I know Barclays had a policy that they weren't going to accept it. So it's always worthwhile checking the UK Finance Handbook just to make sure on there. But I think actually this policy does give them the cover they want. So even if you have a situation where a lender says they won't accept it, it may be worthwhile just trying to explain the protection they get on there.
Okay. And so, Robert, with regard to this sort of new policy, will you distribute it to delegates so as and when it goes live and it becomes active?
What we'll do is, we'll send details out to anyone who's been here. And the other thing I was about to say actually is the ground rent policy is already available. Right. So what we'll do is we'll send some details of that out with the notes and slides. We'll send those out this week. But also then if people are interested in seeing the specimen policy and some more information, if they just reply to that, we'll certainly happily send those to them.
Fantastic. Thank you for that. Thank you. I am conscious of time. I have in the notes given you some details with regard to the Law Commission's exploration of rent charges and its suggestion that it was in urgent need of reform. Again, I think really because of the problems associated with leasehold and of course other issues, obviously, the government isn't sort of really looking at this urgently. I have mentioned at page 25 the case of Roberts against Lawton. You may be familiar with this case, but this is the one that got everybody fairly scared on the basis that you had a situation where a landlord was able to utilize a default with regard to a rent charge to create a lease and then generate a significant claim relating to costs. And again, this is a tactic that has been used in the past, no doubt will be used in the future to ensure that instead of having to spend administrative time and energy recovering £10 a year, £5 a year, we can immediately start recovering significant costs, £650, £1,500 or so in connection with an unreported matter. So, with regard to estate rent charges, you warn your client. You determine what has been paid in the past, but advise the client that this is not an indication as to what the rent charge may be in the future. If the rent charge is divided, is it apportioned? What is the proportion of costs that should be paid? What is the date on which the payment is due? And you warn the client about the lack of protection relating to estate rent charges. I mentioned that rent charges under the 77 Act can be apportioned and they can be redeemed. They still have the same problems as estate rent charges do from a lending perspective. We've talked about rent charges being legal interest requiring registration. We have talked about estate rent charges being protected by notice, and we have discussed in the past about the use of agreed notices rather than unilateral notices. Remember, unilateral notices can be challenged. If you are dealing with an apportionment or a surrender of a rent charge, then do think about the land registration impact of the surrender, making sure the title is tidied up and cleared up. Alternatives to rent charge, well, deeds of covenant, protected by notice on the register, and our old friend leaseholds. Conclusions. Do watch the point I made about any form of any form of ground rent review connected to indexation. As far as rent charges are concerned, estate rent charges are going to be with us, and all we can do is just warn the client about how detrimental they are to a good and marketable title, how problematical they are to our clients on the basis that there is an element of administration and management that the client is going to have to deal with on an ongoing basis relating to rent charges. Stephen, once again, I've overrun. Once again, I'm going to be in trouble with you for doing that. What I'd like to do is to thank everyone for listening. Ground rent in particular is a real hot potato. So if anyone has any questions or queries, feel free to drop me a note at the email address shown. And with regard to indemnity policies, again, Robert, you'll not be grateful, but I've put your email address on. So if anyone has any questions or queries, instead of bombarding me with them, they can bombard you. Stephen, there will be some questions, no doubt. I'm happy to take them now, but thank you everyone for listening. Robert and Stephen, thank you for your assistance once again.
Yeah, thank you very much, Ian. And I have to say, like, they do take the full hour, Ian, but I don't think I've had one person complain about them being too long. So please do not worry too much about that. We have, oh, sorry, Ian, what was that?
I'll bring some sandwiches next time then.
Indeed, please, yeah. So we'll get them sent out to people. We have had a few questions, Ian, since the halfway point. So we have a question from Zara. She said, what happens if there is arrangement for a third-party management company to collect estate rent charges, but there is no actual separate rent charge title? Is this still classed as an estate rent charge?
Yes, it would be. All that happens is the mechanism for recovery is assigned to a third party. You could ask, what authority the management company has for collecting the rent charge, but it's still an estate rent charge from what you've said.
Excellent, thank you, Ian. We have another question here. I apologise if I get the pronunciation wrong for this name. I think it's Colin or Colleen has asked if the rent charge is not registered with its own title at the land registry and no demands have been received by the current owner selling, so identity of the rent charge owner is unknown. What can be done about this to protect the buyer and the lender where there is no need for a demand to be made for the owner of the rent charge before they take action?
Stephen, that's the nightmare. What I will do is I'll give some thought to what would happen in that situation. I'm comforted by the fact that there isn't a rent owner on the scene. That sort of gives me a bit of comfort, but everything else worries me to death, to be honest with you. What I'll do, if I may, is I'll give some thought to that. And I think what we're saying, Stephen, is we're going to sort of collate, aren't we, all the questions and my sort of views or answers relating to those questions. So that one, as I say, can I reserve? I need to have a think about what we would do. If it was an estate rent charge, I don't think there's anything that we could do. If it was a rent charge under the 77 Act, then I think we could apply. I think there's a method of applying to tribunal for a removal of the charge. The other thing you could do, of course, is if it was not registered but protected by notice, and the notice was a unilateral notice, you could challenge and seek its removal. Actually, that might be a good thing to do, because you're going to pull out of the woodwork anyone that potentially could enforce the rent charge if there was a rent owner that was sort of sitting there somewhere.
Yeah, thank you. I think that's potentially very good advice there. But yes, I think on to your other point, and yeah, we are looking to put together, I think I may have mentioned this before, throughout the 2 series, if you like, that we've had, the first 4 webinars and 4 that we're currently running, we're looking to put together a document with all the questions that have been asked, with answers provided from me, and so that will be available, I would imagine, soon after the last webinar of this series, but I'll keep people posted as to how we're getting on with that. So yeah, I think that's really it for the questions, Ian. So that just leaves me to once again thank everyone for coming along to the webinar today. Please, if you have any questions, any feedback that you'd like to give about how the sessions are run, or anything, or any information you would actually maybe like to be included, please do let us know. Otherwise, I'd just like to thank Ian for another fantastic presentation, and to Robert as well for his contribution. And I look forward to seeing hopefully most of you again next week. So thanks everyone, and goodbye.